Okay, so they say, oh, judge, forget that. There's really secret records out there that we haven't seen yet, you know? So this is the kind of evidence that they're coming up with. And why do they want to make these arguments? Because their whole case hinges on the proposition that all of the probable cases came from Henderson. Okay, and why have they chosen Henderson? Because Henderson just made the 5-gallon lots. It didn't make any retail lots. So.
Yeah, Robin.
All right.
Part 16 is now in session on the committee. Will you go?
Please be seated.
All right. Good morning, everyone. Good morning. Now let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll move to the defense.
Morning, Eric Pepperman for plaintiffs.
Good morning, Your Honor. Plaintiff Park on behalf.
Good morning, Your Honor. My name is James Neale, Pro Hoc Vice on behalf of the United Natural Foods.
Good morning, Your Honor. Joel Anderson, also Pro Hoc, also on behalf of the United Natural Foods.
Good morning, Your Honor. Joel Odou and Matt Kaufman from Woodsmith and Berman on behalf of the Real Water Entities.
Morning, Your Honor. Rob Robbins from Milwaukee.
Good morning, Your Honor. Scott Rasmussen on behalf of Hanna Instruments along with Brittany Lyons.
Morning, Your Honor. Jim Kavanaugh, third-party defendant, Real Water of Tennessee.
Good morning, Your Honor. David Pro Hoc, United Natural Foods.
Good morning, Your Honor. Nicholas Hoffman for United Natural Foods.
All right, does that cover all appearances? Okay, thank you. Anyway, I guess unless there's some sort of agreement, we'll just go ahead and follow the orders. The motions have been filed. Is that fine?
Sir.
That's up to the
Your Honor, that would be fine. I do have one issue I'd like to get taken care of before we start this morning because it affects what we do this afternoon.
Yes.
Your Honor, we have met and conferred with the plaintiffs. We have come upon an agreed upon list of jurors to excuse that will be submitted to the court at 4 o'clock today. But we had a question on that, if I may.
You have the floor, sir.
Your Honor, we have certain jurors who did not check the box that they were unable to serve, but in looking at their questionnaires, there were reasons why they would be unable to serve. And it was unclear to the parties whether we could reach an agreement to excuse those, such as people who have difficulty understanding and speaking English.
Well, that's a statutory requirement, so.
And so it would be our proposal to include those on the list given to the court so we don't have to deal with them at a later time. In addition, there were people who checked the box that they could serve, but then when you look at their questionnaire, there were reasons why they couldn't serve, such as health issues and things like that. Again, in talking to the plaintiffs, they didn't believe that this was the round to excuse them. The defense believes this is the time to excuse them. And we argued extensively to have a very, very long questionnaire and to not use those questions and those answers felt inefficient for the defense. And so we had more people to excuse than the plaintiffs. And certainly if they don't agree, we can put the parties do not agree. But we didn't want to put a burden on the court to have a list of, dozens, if not a lot more than that, jurors where the parties were not unable to agree, where it's fairly obvious that a juror can't sit for a particular reason. So we wanted to get some clarification from the court.
All right. And we'll hear from the plaintiffs. Mr. Pepperman, sir.
Your Honor, I think that misses the point of the issue here. Certainly they look through the questionnaires and have said that there are some jurors who we shouldn't even bring in, who we should be excused, even though they didn't mark the box as having hardship, or they checked the box saying they could make the sacrifice to serve. Some of those we've gone through and agree that we can excuse them. Others we disagree. I don't think it was the court's intent for us to submit any disputes to the court to figure out. What we want to do is submit the list of everyone that we agree to excuse based on the jury questionnaires, and to the extent we disagree, rather than having the court review the jury questionnaire to see, oh, should we bring this person in or not, we bring them in, and if they have a hardship or are unable to serve, they can tell us that during jury selection. My concern is we do not want to put that onus on the court to go through every single dispute that we have and essentially rule on them in advance.
I mean, ultimately, I'm gonna have to deal with that issue, right? And I just wanna make sure the record's clear. As far as the panel members are concerned, I went down, I swore everyone in. I also talked to them regarding, in a general sense, pertaining to their obligations to serve. I probably spent about 10 minutes with each panel. In fact, I go back down again, I guess, on Thursday. And so they were sworn in. I just want everyone to know that. But I think this is my concern, and time is of the essence as far as this matter is concerned. And what I mean by that is I don't want to spend a lot of time on obvious hardships, because I don't mind telling you I look at hardships much differently. In this case, it's going to go longer than 2 weeks. But at the end of the day, financial hardships have an impact. And I think sometimes we forget that as lawyers, but it really and truly does. And I'll just have to deal with it on an issue by issue or a questioner by questioner basis. That's all we got to do. So if you don't have steps, I'll just look at them.
But you want to look at every single one?
Where there's not every single one, but where there's a dispute.
And, you know, the problem, Your Honor, is I think there's a little bit of jury selection starting in this process. So it appears to us that the defense are raising hardship arguments to people who really don't want to do it for other reasons. So, and, you know, I understand that, but I don't think that's the appropriate place for this. I mean, we took a real close look at these hardships, and we agreed to them when we had to. So I mean, what he called a hardship, I think is a technique to get an unfavorable defense juror out.
Right.
So I just don't see how we can just submit it to the court without, you know, more extensive briefing.
But I mean, I don't see right now I'm flying blind. I don't know what the issues are. For example, someone, I mean, they didn't check the hardship box out, but they, in their responses, they talked about financial issues or health issues and things like that.
Yeah, Judge, I think that comes out real quick when you, I hate bringing them in here again, but I think you get through it real quick.
I'll have to see what's at dispute first before I make a decision.
And those are the ones where we didn't reach.
How many of them are there?
There's a lot, Your Honor. Your Honor,
There's a lot.
there were people who didn't check financial hardship, and then when you read the questionnaire, they say they live paycheck to paycheck and are having difficulty meeting their bills and they will not be paid to sit in this trial. To us, on the defense, that was an obvious person to be excused. It was one of the very first ones that we listed, and plaintiffs say, well, they didn't check the financial hardship box, so we disagree. If that's the position they want to take, that's perfectly fine.
I gotta see it.
Yes, we're happy to submit it then, Your Honor.
And Your Honor, for the record, we don't disagree with a lot of the hardships, even if they didn't check the box. If there's a travel plan or a severe, obvious financial hardship. But there are several where, yes, they say they have, you know, difficulties with bills. In some scenarios, it's possible that their income is going to be substituted or
When you say substituted, what do you mean by that?
some of them were saying, well, I'm having trouble paying my bills, but they make $600 a month. So there's questions of, given how much they're gonna make as a juror per day, plus whether they're able to work on the weekends. There are just questions that we said, well, this may not be a hardship that is really a hardship that justifies excusing them. So it's ones like those that we seek to bring in rather than just automatically excuse because they say a magic word. So we went through these and meaningfully agreed to the ones that we agreed to, and then any ones that we didn't, it was mostly because there's some questions that we think additional information is necessary before we can stipulate to their hardship.
Or a better example, Your Honor, there's somebody in there who's was relatively high up in the military, retired, obviously getting a military pension, but so they didn't put hardship, but they claimed financial hardship. That's on their list, okay? So I think when you get this guy in here, you'll see that he's making X amount per month from his retirement. Maybe he does have financial hardship, but I don't really think it's one that we would consider necessary to excuse him.
I understand, but my point is I need to see him first before I.
So would you like us to go ahead and submit what we did and what they did, and then you'll have to go through them, or what?
I would like to see what's in dispute.
Okay.
Not what each side did, but what's the genuine dispute?
And one other clarification on that, Your Honor, is a lot of them that are in dispute are based on biases. Do you want us to exclude those?
Well,
just-
I mean, now we've opened it up.
That's what I said at the very beginning.
Yeah, I mean, if there's, hardships are different than biases, right? And biases are statutory, we know that. And just as important too, when it comes to issue your voting age, that's statutory. This is important too. You're required to be able to speak English, you know that, and read English, that's in the statute.
Right. We have some that I think don't speak English that were not excluded. We'll basically.
This is what you do, this will make it easier.
Okay.
If you get copies of the of the questionnaire, and just do a matrix form here, just a list so I can see it and go through it, and what the issue is.
Who would you like to provide that box of disputed ones to you?
I don't know, I don't know.
Because I think it needs to be a joint submission.
I don't disagree with that, Will. I agree with you.
Okay, that makes
We
sense.
have the matrix, but to get the actual questionnaires and attach them is gonna take some work. That's not something that we can do by 4 o'clock today if we're
Well,
here.
but remember, we have time,
Okay.
right?
So
We have
if
time.
you'll give us maybe Wednesday, Thursday, we'll get you that box of all of them and make it a
Yeah.
joint submission.
Perfect.
Yeah.
Thank you, Your Honor.
Thank you, Your Honor.
So I guess first up on, anything else before we get started? So first up would be defendant United Natural Foods West Inc.'s motion in limine pursuant to EDCR 2.47 to exclude declaration and deposition trial testimony of Sarah Sandstrom and motion for discovery sanction. Sir.
Thank you, Your Honor. Mr. Stevens, this is our MIL0. Your Honor, Jim Neale, on behalf of UNFW. As the court may know, in coordinated litigation, our firm also represents Whole Foods. So 90 seconds worth of background here, if I may, Your Honor, and then I'll get to the dispute. The Gallagher case involves 7 plaintiffs. 2 of them are suing UNFW. Only one of them, Mr. Keith Haley, is at issue here today. Mr. Haley and Mr. Belsky, Your Honor, alleged that they drank the retail bottles, like the one in my hand, as
So I
opposed.
understand there's retail bottles, there's apparently a 5-gallon bottle, I mean, I get it.
Okay,
I've read it.
all right, sir. Those retail bottles are, of course, sold at stores. Whole Foods is not a party in the Gallagher case and would like to stay that way. It has a strong interest in staying out of litigation whenever it can. One of the things we have litigated in this case and done a lot of discovery on is the exposure that each plaintiff subjected himself or herself to, how much real water they bought and how much real water they drank. Mr. Stevens, if you could pull up the Haley 1185, the employee ID. Mr. Haley is a Whole Foods employee, and as one, he has this employee team member card, the next page, please, John. And on that card, there's a unique identifier, a barcode and a number that he can use to obtain a 20% discount on all of his purchases at Whole Foods. And Whole Foods purchases, Your Honor, are what allegedly brings UNFW into the case because we distribute, among some others, to Whole Foods. Mr. Haley does not have receipts. Mr. Haley does not have photos. What we did, Your Honor, was take his employee discount card, that barcode, and ask Whole Foods to provide us a list of purchases that he made using that. John, if you could pull up, please, Whole Foods 0181. This is a spreadsheet that Whole Foods provided in response, Your Honor.
But they didn't prepare and provide the in-store purchase.
They did, Your Honor. This is the in-store data. The in-store data,
Is this the spreadsheet
this is the spreadsheet.
that was prepared by counsel?
No, Your Honor. This is not prepared by counsel.
Okay.
That's the allegation.
I mean, because to me, and I've gone through these, this somewhat from a, I can't remember which motion it was, maybe it was,
Well, the motion strike the answer, Your Honor.
Yes.
And motion eliminate 16.
yeah, they kind of go hand in hand. But go ahead, sir.
And I know we're not getting to the merits of that now, but I want to explain how Ms. Sandstrom came up. On your screen, you'll see some of the store data, Mr. Haley's purchases. Now, this store data, Your Honor, that we provided initially showed his purchases from June of 2019 until August of 2019 when he was hospitalized. There was nothing in there about real water. And so we, at the plaintiff's request, expanded that search, and before he was deposed, provided more extensive data from January to all of 2019.
Are these the Excel spreadsheets at issue?
Yes, sir, but not in this mode. Yes, this is one of the Excel spreadsheets at issue. All right, Mr. Haley was deposed. He was understandably unable to give us specific dates when he purchased water or specific quantities. And we lacked any documentary proof of it. Thank you, John. And so that's where Ms. Sandstrom comes in. She is a co-worker of Mr. Haley's. She works in the Reno, Nevada Whole Foods with him. She has for more than a dozen years. She was deposed on May 26th. Mr. Haley was deposed February 2nd, I believe, early February 2023. After that deposition, the plaintiff's counsel or someone from the firm interviewed Ms. Sandstrom. I want to be really clear about this, Your Honor. We're not alleging an improper ex parte communication or a violation of SCR 182. Ms. Sandstrom is not a speaking agent for Whole Foods.
So we don't need to have a discussion on the Palmer case, that's what you're saying, right?
Well, I think we do, only to the extent that Palmer makes clear that attorney-client privilege extends to all employees in the corporation. But that's the only point that I think Palmer is relevant for here. We agree that nobody in the plaintiff's shop did anything wrong in approaching Ms. Sandstrom. We agree that Ms. Sandstrom didn't do anything wrong in talking to the plaintiff's counsel. Now, when they did talk to her, they didn't inform her, as I might have, that Whole Foods was an adverse party in other litigation, or that Whole Foods was a potential defendant in this case. But setting that aside, they spoke to her, and they obtained, Your Honor, a declaration from her. They asked her to sign an outward force-facing affidavit where she set forth what purports to be her recollection at the time. This was February 22nd, 2023. And I think we've all seen that, Your Honor. There's nothing wrong with approaching a fact witness. We're not arguing that we get the attorney or the paralegal's notes who did that. That's work product. We're not arguing that we get to get even a tape-recorded statement of that, because that's not an outward-facing document. But a declaration was drafted and signed and sworn to for one reason and for one reason only, and that's to use publicly. That's to keep the witness on a leash. And that's to break the glass in case of emergency when the witness starts to wave. And Your Honor, that's exactly what happens. The affidavit says very clearly, at some point in 2019, the calendar year in which Mr. Haley was hospitalized, I sold him some real water. Don't know how much, don't know when, but sometime in 2019, within a several-month window. We sat down for a deposition on the 26th, Your Honor, and I was in the unenviable position of not knowing that my client had signed a declaration for opposing counsel because it hadn't been disclosed. It hadn't been disclosed in the 4 16.1 disclosures that were filed between February 22nd, 2023 and May 26, 2023. It hadn't been, even its existence hadn't been disclosed. There was no claim of privilege over it, no claim of work product. We just didn't know it existed. If we had, Your Honor, I could have taken that declaration and sat down with Ms. Sandstrom and compared it to employee files and work dates and purchase records. I could have gone back and shown her the sales history of this product for the store so that she would know when they started selling it, so that she could have put all of that into context and come to that deposition knowing what in the declaration appeared to be corroborated and what did not. So the plaintiff's attorney then attaches that declaration to the deposition without ever having disclosed it before. And, Your Honor, again, we think that's, I want to be very clear about what it is and what it's not. It's not a violation of SCR 182 or Palmer. It's not a failure to disclose a witness under 16.1. We're not alleging that. We knew who Ms. Sandstrom was. We knew she had facts relevant to the case. We got those from her. We're not arguing that we should be entitled to the attorney's notes of that interview. But we are arguing that an outward-facing document like a declaration that's intended for public consumption should have been disclosed. And if they considered it work product, they could have listed it. We could have come to the court and said, this is why it's not work product. And they could have said, this is why it is, and the court could have made a decision. But instead, Your Honor, we were taking trial testimony from a witness who will not be available and whose deposition will be available for use under 32A4. And we didn't know about the existence of that document. And that's a violation. That's a violation of 16.1A1A2. And that's a violation of the administrative order at 2208.
How is that? Why don't we cite administrative orders? I wondered about that.
Because the administrative order on page 4 and 5, if you could pull that up for us, Mr. Stevens, requires counsel to disclose the existence of documents they intend to use at depositions before the deposition. It's very clear about that. In fact, in very strong terms, it calls the failure to do that gamesmanship. And I don't know that I would always agree with that characterization. But 16.1.
And who drafted, I want to make sure this administrative order again is from who?
Well, Your Honor, it's from Clark County. If you could go
Who's
to
it from?
the chief
I don't
judge.
mind telling it. I mean, the chief judge doesn't tell me how to exercise my discretion as a trial judge, right?
Your Honor, let me remove the administrative order. You made your position clear.
Really?
I think
And I don't have any position, but I mean, a chief judge can't tell a trial court, a fellow trial court, how to exercise their discretion.
fair enough, Your Honor. I think the chief judge can tell us as litigants what is expected, and that's the way we took it. Setting that aside, 16.1 requires the disclosure of documents. And, Your Honor, the declaration is, of course, an out-of-court statement offered for the truth of the assertion. It's hearsay. The plaintiff goes so far in their reply brief to say that it's consistent with her testimony. If it's consistent, then there's no prior inconsistent statement exception available, and the declaration should be excluded for that basis. When the witness was at deposition, she expressed a great deal of uncertainty about the dates on which she sold Mr. Haley this property. The declaration, which says something different than that, should not come in. It shouldn't come in because it wasn't disclosed under 16.1, and it shouldn't come in because it's an out-of-court statement offered for the truth of the assertion.
How should I exercise my discretion? What standard should I look at?
16.1, Your Honor.
Well, I mean,
And
when you say 16.1, what are you talking about? What portion of 16.1 should I?
A1, A2, Your Honor, which requires the disclosure of factual information and documents supporting one's claims and defenses. We shouldn't be seeing documents for the first time at trial. And that's exactly what happens with an unavailable witness whose deposition is taken.
I mean, I understand that provision. What does that provision say as far as how am I to execute? Is it self-executing, or do I look to other rules?
Well, I think it's self-executing.
And where does it say, show me where the word self-execute.
Well, Your Honor, I'm sorry, I don't have the ability to do that right now. Let me try to pull it up in just a second, and I'll do that on reply if you'll indulge me. I think the document's also hearsay. I think it's an out-of-court statement offered for the truth of the assertion from an available witness that the plaintiff maintains is consistent with her testimony. That would make it inadmissible under NRS 51. So for those reasons, Your Honor, we're asking for the exclusion of that declaration. We believe the witness testified. Her testimony, as ambiguous as it is, can come in. But that allows for the cross-examination that is the hallmark of the trial. And that's what the jury should see, not the result of an ex parte communication months before that was kept under wraps until trial. Your Honor, there's a counter motion. I'll address that on reply unless the court would prefer me to take it up now. But we ask that the court exclude the declaration from the trial of the case.
Okay, thank you, sir.
Thank you.
But as far as 16.1 and it's 16.1A, 1A, Two, I'm looking here, and as far as the rule is concerned, it doesn't say what the trial court should do.
Well, I think when there's a document that should be disclosed according to rule, and it's not disclosed, I think the natural remedy, the remedy that's commensurate with the law, is to not allow the party to use it at trial, not allow the surprise and not allow the ambush.
Well, shouldn't the appropriate analysis come down to the court performing the Rule 37 analysis and make a determination as to whether there's substantial justification or harmless?
I think 16.1 incorporates all the remedies.
Well, that's why I asked
I'm
you,
sorry.
I asked you the question I asked at the very outset, you know?
Forgive me. Rule
Because-
16.1 enables you.
Well, it's not self-executing. I think that's one of the issues that comes up as far as rules are concerned, because the court, it's like I brought up before, the court has discretion to exercise, and it's within the parameters under the rule, and that's how I exercise my discretion. And that's why I asked the question at the very outset, as far as 16.1A1A2, what standard do I apply? And I asked you whether we're self-executing or not, or is there another standard I apply under those facts and circumstances?
I think 16.1, and it incorporates, as I recall, Your Honor, all of the remedies of Rule 37.
I don't disagree with that.
Okay. And I think that gives the court not only the ability, but respectfully, Your Honor, the obligation, when it believes there's been a failure to disclose that should have occurred.
But Rule 37 is not self-executing. It's not. I mean, I have discretion I have to exercise. I mean, that's straight out of Moore's Federal Practice and Procedures.
All right,
It's
understood.
self-executing. It's not.
Here's why the court should exercise its discretion to exclude this declaration. It deprived me of the opportunity at any time prior to this witness's trial testimony to see what she had said under oath, prepare her and show her the documents that would have legitimately, I think, called that into question. I don't get to take affidavits, keep them under wraps, and then if I came in here at trial, Your Honor, and tried to introduce an affidavit.
But see, that's the difference, right? If you're at trial, in a general sense, and there's case law on this. For example, if the plaintiff failed to disclose the identity of a witness and did so in a pretrial memorandum, but yet the defendant had already disclosed that individual.
There's no harm.
It's harmless, exactly. And so that's kind of my point. It all depends, because, for example, it goes down to, you look at the standard, substantial justification or harmless. I've had cases many times where there might be a misstep taken by one of the parties, but there's time to cure the issue.
And that's exactly what was lacking here, Your Honor, because we have a trial deposition being taken, presenting trial evidence that there are bells that are rung that we don't get to unring. And so for the very first time, I'm seeing a document as it's presented to a witness who is speaking to our jury. I have no ability to discern what's in it, no ability to ask the witness about it, to investigate it, to come up with evidence that might call it into question. That's the exact opposite of everything upon which our civil discovery rules are built. That's the unfair surprise that Rule 16 and Rule 37 are designed to combat, and that's why the court should exclude the declaration. That's the remedy, and that's the only appropriate remedy when a document is brought in for the first time at trial and sprung on an adversary, and it's particularly appropriate, Your Honor, when the adversary is a represented party, represented entity, let me be careful, who has a vested stake in the litigation in trying to stay out of it.
Anything else, sir?
No, sir, thank you.
Thank you, Your Honor. So a few things. The concern with this witness statement is a completely fabricated issue. Ms. Sandstrom was a fact witness who personally observed Keith Haley drinking real water. We planned to take her deposition, and someone from my office contacted her for the purpose of learning what her testimony was going to be. And as counsel already admitted, that is perfectly allowable under the rules, nothing wrong. I was taking Ms. Sandstrom's deposition, but I did not speak to her myself. So rather than relying on the notes of someone else telling me what she said, we had Ms. Sandstrom sign a statement simply confirming that our notes were correct. So there was no confusion when I took her deposition. This statement is not discoverable. It did not, there was no requirement for us to disclose it, regardless of the form of the statement.
And why do you say that?
Because it was a statement from a witness taken at the direction of counsel. That's Rule 26B3. Those statements are not discoverable unless the opposing party shows a substantial need for the statement, or they cannot discover the equivalent of it by themselves. And can be no dispute that that requirement could never be met. And the rule specifically says, 16.1 specifically says, it's a statement in any form. It's a written statement, a recorded statement, notes of what the witness said. If this was a witness who we had a statement from that was just our hand notes about what she said, and the witness was no longer available for some reason, those notes are potentially discoverable. The notes of what the witness said, not mental impressions, that's something different than the statement. But it's any form is not discoverable unless you can meet those requirements. And they cannot meet those requirements because we disclosed Ms. Sandstrom as a witness. They questioned Keith Haley about who she is, what's she gonna say, why did you disclose her as a witness? UNFI's attorneys interviewed Ms. Sandstrom about her testimony. They had unlimited access to her. They could have asked her if she talked to plaintiff's counsel or anyone from on behalf of Keith Haley. They could have asked her if she spoke to Keith Haley, what she told us, if there were any statements. I mean, this suggestion that we ambushed them or there was some surprise, there was no surprise. We didn't do anything wrong. We interviewed a witness about the testimony she was going to give. We took a statement from her, and then we deposed her on it. And even if there is some argument that we did something incorrect or should have disclosed something sooner, even assuming that were to be true, which we did, which I submit we didn't have any requirement, there's no harm from it. We did nothing wrong, and UNFI cannot articulate any harm from this. It's a completely fabricated harm that they're complaining about. The reply accuses us, and Mr. Neale just mentioned that the problem here is that we use the declaration to keep Ms. Sandstrom on a leash, to keep her on script, is what the reply says. But that bald assertion is...
I mean, all statements. I mean, I look back and I probably had investigators take thousands of statements. And you do that to refresh the recollection of the witness, because as time lapses from the event until you're in discovery, they many times forget the details. They just do, you know, and that is what it is. But that's why you take statements. That's why you memorialize fact witnesses in writing if you get a chance, because as time lapses, their recollections aren't going to be on the same level.
You're exactly right. And even in that case, that's even a little different than what we have here. Because I didn't introduce, it's not like we sat down for the deposition. I said, oh, here's your declaration. That's not what happened. I didn't even intend to use the declaration unless she needed some recollection refreshing, but she didn't. I asked all the questions. She gave all her testimony in response to my questions. She said, Yes, I sold him, I saw him on multiple occasions drinking real water. I personally sold him real water on multiple occasions when I was working as a cashier at Whole Foods. I remember him having discussions about real water with him. I remember him joking about real water. He made the same joke to everyone. Look, it's real water, it's not fake. They corroborated everything he said she was going to corroborate. She corroborated everything Mr. Haley said she was going to corroborate, and she described the bottle. She remembered with recollection. I did not use the declaration to keep Ms. Sandstrom on script. I asked her for a recollection, and she told us her recollection was her oath, which was consistent with the declaration. After she gave all this testimony, I asked her if she spoke to defense counsel. And she said that she had. And I asked her what they spoke about. And counsel intervened and instructed her not to answer our questions. A fact witness who we were asking about her personal observations, he said, no, you can't find out that information. You can't seek the truth on that. Whatever I said to her, that is some sort of privilege, which it's not. There's no privilege that he had with this fact witness about her personal observations just because she's an employee of a party that they represent in a different action. Ms. Sandstrom is not a witness in any other action than this one, where Whole Foods is not a defendant. She's not a witness for any other purpose other than her personal observations seeing Keith Haley drink real water on multiple occasions during the spring and summer months of 2019. So she went during this questioning, she brought up the declaration. So rather than make this a big issue over nothing, when she referenced the statement, I showed her the statement, confirmed with her that it was consistent with the testimony she just gave, confirmed that everything in the statement was true and correct, and confirmed that she stood by it. UNFI, after I was done, questioned her about the statement. He questioned her about our interview of her, what she told us, the circumstances of this statement. She confirmed, yeah, they called me, I told them this, they asked me to sign it to confirm that it was correct. Everything they put in that statement is correct. I stand by it. Everything I said was true and accurate, and it was all consistent with the testimony she already gave before we ever even introduced the statement. This whole thing about failing to disclose a statement that was our qualified work product until we did, and violating 16.1, which we disclosed the statement during discovery, well before 30 days before trial. It was consistent with what she had already testified to. There is no rule violation, even if you could stretch these facts to implicate a rule violation. Any reason for the delayed production was substantially justified because it was in reliance on the qualified attorney work product privilege. And on top of all that, it was harmless because it was consistent with what she said, and they had every opportunity to depose her on the statement. She answered all their questions. The real issue here is what we were deprived of, our fact-finding efforts, based on a frivolous assertion of an attorney-client privilege with someone who is an employee of an individual who's not a defendant in this case. Counsel argued that, you said, that they admit she's not a managing speaking agent. That's obvious. And you commented, well, so Palmer is not an issue here. And he said, well, only to the extent that Palmer extends the attorney-client privilege to all employees. Well, Your Honor, I strongly disagree with that statement. Palmer does not extend the attorney-client privilege to every employee, however low level of a defendant. It may apply to a communication.
Well, that's straight out of Palmer. I mean, I have it right here in my notes. And you can correct me if I'm wrong or not, but in my review, they cited Wright versus Group Health with approval and also noting that attorney-client privilege applies to employee communications with the organization's counsel. The privilege protects only communications and not facts or the employee's knowledge.
Exactly, that's the difference. That's exactly the point. It can extend if they're talking about the litigation or it's in relation to their representation of the client. But Whole Foods is not a defendant in this case, for number one. And number two, she has no information related to anything regarding the representation of Whole Foods in any case. She has personal knowledge of observations of Keith Haley, a plaintiff in this case, drinking real water. So there's no reason to think that they were communicating with her about anything other than her personal observations, which are relevant in this case. And counsel even admitted that when he said, oh, if we would have just produced a statement earlier than we did that they never asked her about, then they could have prepped her and showed her all these fake Whole Foods purchase records and got her twisted around. Well, they tried to do that anyways. But even if they were to do that with her, we would be entitled to know that. We are entitled to discover those communications, which have nothing to do with his representation of Whole Foods and everything to do with him trying to convince her to back off her sworn testimony that she personally observed Keith Haley on multiple occasions drinking real water, sold them real water on multiple occasions during the spring and summer months of 2019 by showing her fake records to say, oh, well, look, these contradict. Are you sure? Are you sure? Are you sure? That type of influence bears on the credibility of the witness because she said, yes, I'm sure. I remember. It's 2019. I remember. I don't know how many times. I wasn't counting. I can't tell you the exact month. I feel like it was in spring or summer because I remember trying to remember the weather outside. It was that general time frame. And those are credibility issues, especially given these fake Whole Foods purchase records, which you
And I
understand.
want to
is
make
a
sure
significant-
I'm clear in this respect because it appears to me that the declaration is not that factually intensive. It's not like an expert declaration or anything like that. And here's my point. At what point was the declaration attached to the deposition transcript during the deposition?
Page 25 of the
Okay.
deposition.
Right.
I asked all my questions, and it was at the very end. And as soon as she
So
confirmed,
the deposition was only 25 pages.
my questioning was 25 pages. It was 22 pages, I think. Then the issue came up with I instructed her not to answer. Then she referenced the declaration. I introduced it. She confirmed that was everything, and I passed the witness. That's the chronological order of what happened.
And what date did that occur?
That was May 26th. There was the deposition. And respectfully, Your Honor, just to sum up on the declaration, we believe that that statement was privileged work product and did not need to be disclosed. Okay? Even if there's some question or argument of whether it was not work product or should have otherwise been disclosed earlier, and there was some mistake, which I firmly believe there was not, but even if there was.
And was it your deposition?
I took the deposition, yes, sir. You noticed it? There was at least substantial justification for the disclosure when we disclosed it, and it was harmless for all the reasons that we've discussed. What was not harmless was the instruction to a fact witness not to answer our questions bearing on her facts and knowledge that she underlined her testimony. That is not harmless because it deprived us of our ability to seek the truth, to find out if UNFI's counsel was attempting to influence her testimony, which would bear on the ultimate determination by the jury on how how the jury values the testimony. I mean, the fact that an opposing party is trying to back off a fact witness to change her personal observations is pretty strong evidence that that information is bad for the opposing party. And so we were deprived of that right, and I think that we should be given a curative remedy, something that remedies that harm. And as we suggest in the opposition and counter motion, we think the way that you remedy it is you instruct the jury when Ms. Sandstrom's testimony is played that she was not able to answer these questions because she was wrongly instructed not to do so.
I mean, you say these questions, what are you talking about?
The questions about what UNFI's counsel talked to her about in its interview of prior to the deposition. Because the only assumption from that is that what she was going to say was not going to be good for UNFI. That's why you instruct the witness not to answer a question based on a protectual attorney-client communication that is not even with a defendant who's not a party who's not even a defendant in the action. Because you have to assume that what she was going to say was going to reflect poorly on UNFI, which is why they instructed her not to answer those questions wrongly. And I think the jury should be allowed to infer from that they were UNFI wrongly instructed a witness not to answer questions about potentially relevant facts, and that from that they can infer that if she had been allowed to answer, those answers would not have reflected well on UNFI. I think that's an adverse interest, not a rebuttal presumption, even though I think we can make a very strong argument for one. I think that's a fair remedy to cure a wrongful instruction not to answer fact-based questions.
But what, you know, and I understand what you're saying, you're delving into some of the discussions on advanced tables, I get that. But at the end of the day, when I'm looking at it from this perspective, she gave her testimony, right? And it was regarding what happened and how many times the plaintiff had purchased and drunk the water dish, right? That's all, she testified to that.
She did. She testified to certain things, but as you know, what Whole Foods what UNFI has done repeatedly with these fake Whole Foods purchase records.
Well, that's kind of a different issue. I'm simply focusing on her, and I don't know if they're fake or not. I just want to make sure I'm clear on that. But I'm looking, because remember this, and when it comes to, you're in essence asking for a spoliation motion based upon the defense instructing her not to answer. I get that. But at the end of the day, remember, anytime you're dealing with spoliation, that deals specifically with evidence that's now missing. And that's kind of my point. She did testify, right? And she testified in accordance with the declaration. And she was pretty clear there. And so I understand potentially the defense might have instructed her not to answer, and it might have been too broad in nature because she can testify as the facts, not the communications that would potentially involve attorney-client. I mean, I get that, and I understand what Palmer stands for. But what evidence would your client be precluded from presenting at the time of trial? And that's ultimately what it comes down to.
Well, I'll tell you exactly. So what counsel said was, oh, well, if we would have known about her declaration, we could have presented her with the Whole Foods records, or we could have told her that, you know, there's no records of them selling any of the water. And so I have no reason to believe that they didn't already do that when they met with her in advance of her deposition. So if they're making representations to her about what is or what is not in Whole Foods records, and that influences her testimony to say, oh, well, maybe I'm not as sure about the number of times or the dates. So when she came in to testify, she's saying, well, I can't remember exactly the dates, or I only remember, a handful of times, or she's saying she remembers less than she otherwise would have because of this influence prior to her deposition from UNFI's counsel about representations. Who knows what representations they made? That is potentially, yes, she testified to the facts, she testified to her observations, but to the extent that those facts or observations were influenced by the pre-deposition statements or representations made by UNFI's counsel to her, we should have been able to inquire into that, to know about that, to do potentially additional discovery related to that. And we were deprived of that. We were deprived of that testimony to be able to say, well, look, she's saying this, but her testimony was also influenced by these pre-deposition representations. And by instructing her not to answer that, we weren't able to fully inquire into the facts and circumstances of the testimony that she gave. And so that is a spoliation of evidence. We were deprived of that evidentiary, that testimonial evidence, that ability to inquire into that, to find facts. And I think a fair remedy to that spoliation is an adverse inference instruction. So there is harm there. It may not mean that she didn't testify at all or didn't testify largely consistently with her declaration, but that testimony that we were deprived of getting, it colors, it bears on the testimony that she gave. It bears on UNFI's position regarding the testimony, its arguments regarding the inferences that can be drawn from her testimony. And that is what we lost. That's what we were deprived of based on a wrongful assertion of a non-existent attorney-client privilege in this circumstance. And so we do think it is important to remedy that harm. And given that it is effectively a spoliation of evidence, we would ask for the adverse inference instruction on that.
Okay, thank you, sir.
Thank you.
May I, Your Honor?
Absolutely.
You asked, let me start with the counter motion on the privilege issue. You asked Mr. Pepperman what questions the witness was instructed not to answer. Mr. Stevens, could you please play Sandstrom clip number 2? This is the one and only instruction of the witness not to answer the question. And before Mr. Stevens hits play, I'll make this point. The witness was never, ever instructed not to provide factual information in accord with her oath. And a suggestion to the contrary misrepresents the deposition and is offensive. The witness was instructed not to answer questions about her communications with her employer's counsel. Those communications are always privileged. They're privileged whether I'm having those communications with a cashier or a CEO. And they're privileged whether that entity is part of the litigation or is a non-part of the litigation. That privilege is absolute. John, if you can play the instruction, please, and Sandstrom clip number 2.
Prior to your deposition today, did Mr. Neale speak to you?
Yes,
How many times?
just once.
No objections.
When was that?
They can find out when, how many. Did I? All
A couple of
fair.
days ago.
Wait, let me.
And what did you discuss with Mr. Neale?
Ms. Sangstrom, don't answer that question. This is a manager at Whole Foods whom we represent in this litigation. So I'm instructing the witness not to answer on the basis of attorney-client privilege.
It's your contention that you have an attorney-client relationship with Ms. Sandstrom?
With Whole Foods, for whom Ms. Sangstrom is a managing employee, absolutely. You've asked her questions about data analysis and the store generally and ordering practices, absolutely.
with respect to your conversation with Ms. Sandstrom, prior to this deposition, you were asserting attorney-client privilege, correct?
Absolutely.
Well, for the record, we object to that characterization, but obviously that's an issue for another day.
That was it, Your Honor. Don't answer a question about what our communications were prior to the deposition. You can tell Mr. Pepperman we talked. You can tell him how many times. You can tell him when. But you can't tell him what we discussed. That's an absolute privilege. It extends. That's exactly what Palmer says. It's only about the communication. Ms. Sandstrom was allowed to tell Mr. Pepperman everything she wanted to, everything he asked about the facts of which she was aware. I think that should put the counter motion to bed and the attorney-client privilege, unless the court has a question on that. In terms of the declaration, Your Honor, I apologize for not having this earlier, but I'd cite the courts, the Pizarro-Ortega versus Cervantes-Lopez case, 133 Nevada 261. That makes very clear that the failure to make a 16.1 disclosure opens up a party to the 37C1 sanctions and remedies. Yeah, and that's the appropriate analytical framework for the court.
Mike, but everything comes down to timing.
And here's the timing problem.
Well, I mean, Pizarro Ortega, was that at the time of trial? This isn't trial.
This is trial, Your Honor.
No, it's not.
And this is
No, it's not trial. This is pre-trial motions. For example, if there was a potential issue made with any party to this litigation, there's potentially enough time to cure it. It just depends on what my decision is.
all right.
Right? But this isn't trial.
The only cure for this is because her testimony is baked in. She took an evidentiary deposition that is admissible at trial under 32A4. It is the practical equivalent, because she's unavailable for trial, she's in Reno. It is the practical equivalent, Your Honor, of Ms. Sandstrom sitting in the witness stand and being handed her declaration in front of the jury on direct by Mr. Pepperman when nobody else has seen it. That's what happened here. The testimony was trial testimony. It was being preserved for trial. It's going to be played at trial in that video form. I couldn't do that for my witness. I can't walk up to them and say, thank you for your testimony. Now, in addition to that, I want to show you what I consider to be a consistent declaration that you signed several months ago. Here it is. Will you please endorse everything you said in that? And then show it to opposing counsel for the first time after the fact. The court would never allow me to do that. And yet that is precisely what happens with an evidentiary deposition that's taken for trial. That's why there's no pretrial cure for this. And that's why the declaration should be excluded from evidence. It should have been disclosed under 16.1. It's an out-of-court statement that's offered for the truth of the assertion. No exception applies. It's hearsay. It's not subject to cross-examination. That's why we can't bring in declarations when a witness testifies, especially declarations that haven't been previously disclosed. And especially declarations that are presented for the first time during trial testimony.
And I just want to make sure, how the declaration was attached after she testified?
No, Your Honor. The declaration was that Mr. Pepperman, during his direct examination of this fact witness, presented the declaration for the first time. During her, and then continued the testimony.
And tell me how this, I want to make sure I understand procedurally how this was done.
He said, thank you for answering all the questions you answered so far. Did you sign the declaration previously? Is this it? I attach it as Exhibit 1. Now let's talk about your declaration. At that point, Your Honor, the declaration is the testifier. And I'm seeing it for the first time, and it's not subject to cross-examination. That's why affidavits and declarations for available witnesses are not admissible. It's their testimony that the jury should hear. Not an ex parte statement that they agreed to out of court previously. And certainly not an undisclosed ex parte declaration that they agreed to previously. That's why we have testimony. That's why we allow depositions. And that's why we allow under 32A4 that deposition to come in at trial. I've said everything I intend to, Your Honor. If the court has questions, I'm happy to try to answer them. But the declaration should not be admitted into evidence.
Mr. Pepperman, you have the last word.
Your Honor, I would just correct the record that I did my direct examination. I did not introduce the declaration until after all those questions were answered, and she was instructed not to answer, and she referenced the declaration. Then I, just to avoid a fight over, oh, what declaration are you talking about? What statement are you talking about? I just introduced it, and she read the declaration into the record in her testimony and said, yes, I said this, I stand by this. Yes, I said this, I stand by this. Yes, I said this, I stand by this. That's all that happened. It's not the declaration, it's her testimony. She testified to it. So this whole issue about hearsay and the separate admissibility of the declaration, that's irrelevant. And it was after, and he cross-examined her on it. It was after the direct examination, she confirmed her statements that she previously gave, that they were consistent with the testimony she previously gave. It's a non-issue. We didn't do anything wrong, and if we did, there was substantially justified and harmless under Rule 37. There's no basis for any sanction whatsoever.
And I just want to make sure I'm clear on the sequence of events. Are you saying, and I understand now what's going on, this wasn't a discovery deposition, this was a trial deposition that preserved her testimony for the trial, is that correct?
Well,
I'm still unclear on that.
It was a discovery deposition, but she's located in Reno. I don't know if she's going to be available for trial. She's outside subpoena power, that 100% for sure. Whether we're able to bring her at the time of trial, we haven't inquired into that yet or discussed that issue. So it's a discovery deposition.
Okay, but I just want to make sure I'm clear. So you were basically, you had finished your examination, and that's when the affidavit or declaration was produced.
Yes, Your Honor.
And just as important too from the record, I want to make sure I'm clear. When you were asking your questions in your examination, I guess that would be what, 25 pages, give or take, 22 pages?
Yes.
At no point you made reference to her declaration?
No. Did not reference it, did not introduce it, asked her open-ended, direct questions about what she remembered, and she gave all that testimony. On the instruction not to answer, counsel argued that any and all communications with an employee of Whole Foods is subject to an absolute privilege. Can't ask about it. That is incorrect as a matter of law. Only communications in furtherance of the representation is potentially subject to the privilege. That is not an issue here. And you heard the deposition testimony. Oh, this is a manager of Whole Foods.
She had the, similar to the sous chef in Palmer. I mean, you could have an assistant manager at McDonald's. That doesn't necessarily stand for the, I guess, some small area of the store. Maybe the drive-up window, but that doesn't stand for the proposition that you're managing speaking agent for the purposes of McDonald's. I get that.
Exactly. And it's not a managing speaking agent, so it isn't an absolute privilege with everything they discuss with her. And it's only related to communications in furtherance of the representation of Whole Foods. That cannot apply here, because Whole Foods is not a defendant in this case, for one, and number two, she wasn't asked any questions about anything that has to do with Whole Foods. She was asked about the purpose of her deposition, and her testimony is her personal observations of seeing one plaintiff, in this case, drink real water and purchase real water during the summer months that they're saying, oh, no, sorry, look at our fake Whole Foods purchase records. He didn't drink real water. That was the purpose of it. Those are fact issues. Those are not issues related to counsel's representation of Whole Foods in some case where Ms. Sandstrom is not even a witness. There's nothing that relates to it. For them to claim that there's an absolute privilege from everything they say to this fact witness in this one case, whose only relevant knowledge is her personal observations of this one plaintiff drinking real water, that is a farce. That is a deprivation of relevant evidence of what this woman would have said when I asked her, what did Mr. Neale tell you? What did you discuss with him? Did he try to tell you that, oh, you're wrong because there is no, Whole Foods didn't sell any real water to Keith Haley in that time frame? Oh, could it have been a different time frame? Could it have, shaded her testimony or made her question it? Because we know that's what UNFI's done over and over again with these fake Whole Foods records. Presenting them as if they're real and as if they're authoritative in order to try to get witnesses to doubt their recollection and their testimony about seeing and buying real water at Whole Foods during the relevant time frames. And that's what we have to assume they were doing with Ms. Sandstrom, and they deprived us of the ability to inquire into that by instructing her not to answer questions based on an attorney-client privilege that they say is absolute, which is not absolute, and which under the facts of this, there's no stretch of facts that there would be any attorney-client communication privilege that applies between UNFI's counsel and this particular Whole Foods employee based on the only relevant knowledge that this witness would have or was asked about.
And she was a cashier, and she was a supervisor of cashiers, is that basically?
At the time, she was a concierge. She worked at the cashier to help out on different occasions. Currently, by the time she was deposed, she has some supervisor roles, but some supervisor job responsibilities. But as we confirmed in the deposition, she's about 7 layers removed from any corporate, officer or any corporate supervision, managerial role. She testified, we made sure to go through all the factors. She has no managerial control. She reports to at least 4 or 5 people at this one store in Reno alone. She doesn't set policies. She doesn't hire or fire. She is largely a lower level store employee, mid-level I should say, because she does have some supervisor responsibilities. But that's it. And regardless of what her role is, they admit she's not a managing speaking agent. There's no absolute privilege. And she's not asked about anything. She has no knowledge about anything other than her factual, personal observations, which Palmer expressly says, okay, even if there is an attorney-client communication privilege, it's only related to communications in furtherance of the representation. You can't use it to shield the other side from discovering facts or knowledge of the witness, that's all we're doing. But that's exactly what they did. They used this attorney-client privilege to shield our discovery from this witness's, from facts regarding the communication, regarding any potential pressure that was put on this witness, and her knowledge in light of that pressure. It's a critical issue. Because showing that they went to her beforehand and said, hey, listen to us, we're Whole Foods attorneys. They didn't sell it to him. There's no evidence of it. You could be wrong. You could be wrong. That's critical information that we were deprived of. And I would point out that there wasn't any denial that took place. So that just furthers our belief that this is what was going on, and this is what we were deprived of finding out, based on a wrongful assertion of a so-called absolute privilege that's far from absolute. So we would ask to remedy that adverse inference instruction as proposed. Thank you, Your Honor.
Thank you. This is what I'm going to do, and this is what I need. First, regarding Defendant United National Food West Inc.'s motion to exclude Sarah Sandstrom from testifying, I'm going to deny that. Regarding the other two request claims for relief, I want to see the deposition transcript so I have context to see exactly the sequence of events and how they occurred. And then I'll make a decision as to the other two issues after I get that, because it's a short transcript, right?
About 50 pages, Ron.
Yeah, that's short transcript. It's not-
Yeah.
I just want to see how it went down,
Yes, sir.
that I can make a decision as far as that's concerned. And that's regarding the declaration, that's outstanding, and also the counter motion for discovery sanctions. I just want to see how the sequence of events. And how soon can you get that to me?
You can email it right now, Your Honor, or we can get it in paper at lunch.
Somebody have, I don't like emails.
I don't need it.
Just get me a paper copy of the transcript. And also, I assume the declaration is attached as an exhibit, is that correct?
It is, Your Honor.
Oh, and that can be this afternoon.
Your Honor, I have a paper copy of the condensed transcript, and a copy of the declaration. It's informal, but
If you show it to adverse counsel, so we can make copies. Is there any writing on it?
I did not write anything. It's up to you. We can submit a formal one. This is just.
Yeah, you know what I think is important to have a part of the record.
Yes, sir.
Okay. I just missed it. Oh, it was actually submitted this morning. So let me make sure I have everything. Thank you, ma'am, for checking. Is there, I don't know if the declaration, is it attached? This would be, for the record, this would be, I guess, part of the binder, tab 1. It would be, I don't see the declaration.
Your Honor, we did not attach the exhibits to that deposition transcript, so. But it does contain the full
Transcript, yeah.
transcript.
So I already have a copy of the full transcript. How long is the declaration?
It's one page.
Okay.
I have a copy of
Make sure council takes a look at that.
That's fine. That's fine, Your Honor. Thanks.
Your Honor, may I approach?
Yeah, you can go, sir. Thank you, sir. Okay, let's go ahead and move on to the next motion. You see here, and that, I guess, that would be plaintiff's motion for summary judgment number 1 that the real water consumed by Christopher Wren prior to his August 18, 2020 hospitalization was not made at the Henderson plant.
This is a pretty simple motion. This is a fact, and I'm surprised it's even disputed given the current state of the evidence.
Is this the issue regarding the timing of when the plant opened?
Okay, why don't we start out with, I think.
Because you have the DI plant and the Henderson plant, right?
Yeah, according to the information that Mr. Jones provided to the FDA and the Southern Valley Health District in his interview, and I think, Shane, that would be the September 30th date, MSJ 17. Can you pop that up for the judge? So what happened here, Your Honor, is the authorities went and did the investigation, and they went out to the plant, and they interviewed Mr. Jones, and they asked Mr. Jones, this is Blaine Jones.
Could I step down for 1 second? I had a matrix I prepared for everything. We just want to go get it.
Okay.
Could I just take 2
You want to
minutes?
take a 3-minute break? Or?
Yeah, let's take a 3-minute break.
All right.
All right. Department 16, now come back to order. Honorable Timothy Williams, presiding. Please be seated.
All right, I guess we can continue on. Mr. Kemp.
Your Honor, answering your question, James, can you pop that up, please? So after the investigation started, they went out to the Henderson plant and they talked to Mr. Jones. They asked him, well, when did this plant start operations? So this is the information that he gave them, and this is from the government document. He said it started on September 30th. But that's disputed by the defense. And before I get into the dispute, I want to put this whole motion in context. Because this is one of the few things we agree with. They say that this is the key issue in the case, where the probable cases came from, and I agree. And the very first probable case is Mr. Christopher Wren. First off, what is a probable case? Jen, can I have one, please? So what happened here is there was an investigation. Pop up one. There was an investigation that was triggered when a Salt Lake physician saw 5 children come in. 5 kids were flown up there between ages 7 months, 5 years. One of those kids was the Wren child. So they're hospitalized down here. They have very high ALTs, ASTs. Some of them were 2,000 to 3,000, which is incredibly high. So they were flown up to Salt Lake, and the intent was that they would have liver transplants. But they start drinking the good hospital water up there. They drink the good airplane water, and they start getting better. So they didn't do any transplants. But this is what triggered the investigation. The Salt Lake physician got on the phone, and he called up Southern Valley Health District, and he said, hey, this is so unusual. 5 children, all from the same place, in a constricted time period. Something must be going on. So they started the investigation. They focused on the 5 kids first, and again, it's like I've already indicated, one of these is the Wren infant. And then they started looking at their household members. Can I have the next one, please, Shane? And Judge, this is from the article that was published in the MMWR. This is what I'm reading from, which is a publication that the Southern Valley Health District and the CDC did. So multiple household members from 2 households reported vomiting at the same time, pregnant children. 1 adult household member hospitalized with unexplained liver abnormalities 7 months earlier. That is Christopher Wren. He is the first outbreak case. Next one, please, Shane. So this is the definition of probable. Remember, I just referred to it as probable cases. What the health district did is they didn't want to investigate every acute liver injury that happened in Southern Nevada in the last 2, 3, 5 years. So they had a time frame cut off. And the time frame was August 1st, 2020. So the definition of a probable case is You got a new case of hepatitis, can't be explained by something else, it happens afterwards, and they can't find a potential cause. So that's the definition. Next one, please, Shane. This is Mrs. Ryerson, or excuse me, there's 21 probable cases. The probable cases include Christopher Wren, and that's important because one of their arguments is that for some reason, one of the probable cases isn't similar to the probable cases. I don't get that argument, but that is their argument. But in any event, there's 21 probable cases, including Wren, and in this case, go ahead, Shane, next one, please. This is the woman who died. This is Mrs. Ryerson. She's a plaintiff in this case. She's explicitly identified as a probable case in the MMWR. Next one, Shane. Okay. I brought this up because I wanted to address this issue right at the outset because the defendants have misconstrued this in almost every deposition I've been at. In this report, which is published in October 2021, excuse me, November 2021, they say that they haven't identified the substance that's caused the illness, and they say it's not clear whether it's just the 5 gallons or others. This is what they say in the report. This report was drafted prior to the time that the FDA concentrate results came. The FDA concentrate, and we took the deposition of Dr. Zhang, who's one of the co-authors, and we said, okay, you've got this report that's joined in by a number of people. I think there's 8 people on it, including Dr. Zhang, she's the lead one. When did you start drafting this? When did you write these words? Was it before the concentrate test, or was it after the concentrate test? Because they like to stand up and say, oh, Judge, it can't be hydrazine because the Southern Nevada Health District didn't say that, okay? So the point I want to make right now is this was drafted before the FDA concentrate test. Can I have that next one, please, Jade? Judge, this is the concentrate test. So what happened is I told you they went to the Henderson plant. They took what is called a concentrate. And I'm going to explain that in a lot of detail in a couple motions prior to that, but just real quick. They made concentrate, they mixed the concentrate with purified water, and then that's what became real water. So the FDA went in and they took 3 concentrate samples, and they found that there was 1.44, 1.75, where's the next one, Shane? I think it's 1.33. Yeah, there it is, bottom left there, 1.33. They found hydrazine in the concentrate. Let's see the date of that, top date. If you see, this is the date that comes out of the lab. So these results come out of the lab on October 18th, 2021. This is after this MMWR has been circulated for publication. It's right before the publication, but it's after. And so every time they stand up and say, oh, the government didn't say anything bad about hydrazine, that's because the MMWR was published, drafted before the hydrazine results. Next one, Shane, please. This, I think we skipped the Burke article. I just wanted to put this in context, Your Honor. This is what's called the Burke article. Prior to the MMWR coming out, there were some scientists at Loma Linda that wrote this article. They looked at 4 real water cases, published this article. This is subject to a couple motions coming on. I'm just trying to put it in context. This was actually cited by the MMWR as authority. Okay, next one, Shane. Now, why is this all important? It's important because their position, UNF's position in the case, is that all, they say this over and over again, all of the probable cases came from Henderson. Our position, based on the undisputed evidence, is this is just not true. Why is that? And they call this the key issue in the case, and I agree. Why is that the key issue in the case, Your Honor? Because if all, as they claim, all of the probable cases came from Henderson, that argues for a Henderson-specific problem. If some of the probable cases came from Desert Inn, again, that's the operation before Henderson started, the Desert Inn operation lasted for years. If some of the cases came from Henderson, and some of them came from Desert Inn, then that would suggest a problem that's common to both plants, such as finding hydrazine in the concentrate because the exact same concentrate was used for both plants. So that is why this motion addresses the key issue in the case. Now, the very first probable case is Christopher Wren. And this is Christopher Wren's hospital record, Your Honor. The only reason we have offered this hospital record is to show the date of admission. As you can see, he was admitted on October 24th, August 24th, I'm sorry. And it explicitly says that he started vomiting 5 days earlier, which is August 19th. So again, this is an outbreak case. The Southern Nevada Health District, the CDC, has said that Christopher Wren, and also his son, are both outbreak cases. But he is the very first time-wise outbreak case.
And what was the vomiting again, 5 days before?
It was 5 days before
The
this,
19th?
which would be August 19th. Next one, Shane. This, so real water was sold in 2 different ways. It was sold in retail bottles through stores such as Whole Foods and Costco and Safeway and Albertsons and Terrible Hertz and Green Valley Grocer. And it was also sold by home delivery, 5-gallon jugs. In our case, we have 2 people that are primarily retail bottles. That's Haley and Belsky. And we have 5 people that are retail jugs, which are the other 5 plaintiffs. This is a record from Real Water about its home delivery date to the Wren household. Emily Wren is Christopher Wren's wife. This is the last date of the home water delivery prior to Christopher Wren getting sick. As you can see, it's dated August 13th, 2020. Why is this important? This is important because if the Henderson plant is not in operation by August 13th, 2020, it could not possibly have been the source of Chris Wren's illness. Okay, so that is why this is the key date. And again, I've already showed you, what he told the FDA that the Henderson didn't start until September 30th. And there's pretty compelling evidence for that, but this is the key trigger date for this motion, August 13th, 2020. Next one, Shane. Okay, this is their argument, okay, or excuse me, these are the issues in the case. Maybe we ought to skip over to the timeline, Shane. Let's do the timeline, that's probably better.
Which MSJ was that, Mr. Kemp?
That's in MSJ 1 on page 3, I believe. Yeah, bottom of page 3. Yes, we put together a timeline because it started to get confusing, all the things. Bottom of 3, that's MSJ 6.
You're on MSJ 6.
It's the reply sheet. I'm sorry. There we go. All right, Judge, this is the timeline. Okay, August 10th, the date of the eviction order. As you will see, this is the only evidence they have that suggests that, and they call it evidence, I don't think it's evidence, but they say, oh, there was an eviction order filed in Justice Court on August 10th pertaining to the Desert Inn facility, so that must be the day Henderson started. Well, a couple points here, Your Honor. Number one,
I mean, I know what an eviction order is.
right, I mean, if everyone moved out the day you had an eviction order entered, we wouldn't have landlord-tenant court, okay? So they claim that the eviction order was entered on that day, and then they claim that this thing called a filling machine, and what that is, it's a big thing that's about as big, maybe not quite as big as a Winnebago, but the jugs go in circles and thing goes down and it fills the jug up. It's a big item that was at the Desert Implant that was ultimately moved to Henderson. They claim that's the day that the filling machine was moved, okay? Because if the filling machine isn't moved to the Henderson plant, you obviously can't make 5-gallon jugs there because you have to fill them up. All right, the next date on the timeline is August 11th. That's the date that Real Water actually took possession of the Henderson plant. And we know that date because it comes from a email by the landlord that says, here, we'll give you the keys. So their argument is so ridiculous, Your Honor, that they are actually claiming the machine was moved in the day before they even got the keys. All right, the 13th is the date I've shown you. That's the last home delivery date before Mr. Wren was injured, okay? The 18th, and this is what they didn't tell
As
you.
far as Mr. Kemp, as far as the home delivery, is there any way to tell when specifically those, were these 5-gallon or were these the retail?
They were 5-gallon, but I think Your Honor is focusing on some kind of product identification code to say the same manufacturer. That would make things too easy in this case.
How did you know I was going there?
Your Honor, unfortunately, on the 5-gallon jugs, there's not a product delivery date. So the best evidence we have is the date it was actually delivered to the household on August 13th. 18th, you know, like I've already said, they placed reliance on this August 10th eviction date. They didn't tell the court that there was another order that came out on August 18th from the Justice Court where they rescinded the eviction order. Okay, and I'm going to show you it because the landlord came in and said they paid the rent. And put this in context, we're talking August 2020. We're at the height of COVID. A lot of people are behind on their rent at that point in time, Your Honor, especially businesses in this town. But in any event, the eviction order was rescinded because there was a rent payment. And we got August 18th, Mr. Wren vomits. The 20th, he's hospitalized. It's actually, I think, the 21st. And then 2 weeks after, I'm taking their date. I'm taking his date that he told the court that fill machine was moved. He told the court that it was moved on August 10th. That is impossible. That misrepresents all the evidence. But let's give him every benefit of the doubt and take that August 10th date. There is testimony in the record from Mr. Jones that it would take at least 2 weeks to get this fill machine up and running. That takes us to August 24th. That's after the Wren delivery. So giving him every possible benefit of the doubt, it's after the Wren delivery. Next item there, that's production records from the Desert Implant. Remember I told you that, you know, as Mr. Jones told the FDA, the Desert Implant was still going in August, late August. So we went and got the production records of this, his initials are JR, but his real name is, I think it's Chavez or Chavez, we have it in motion. This is the day he was at the Desert Implant making real water, and there's production records. Okay, UNFI, I mean, it's so disingenuous. They go, oh, Judge, you can't rely on these production records. They might have just been using the same ones over at Henderson, even though they say DI. But that's their argument. The very next day, Mr. Akins is called to work at the Henderson plant. He's the one that, as we get into a little later on, he made what I call the super bad batch, but I think he admits he made a bad batch. But he wasn't even called to work at Henderson until September 1st, which is, what are we at now? 18 days past the delivery date. And then we've got the September 30th date, the day that Mr. Jones tells the authorities that the Henderson plant starts. And then on September 30th, we have the very first handwritten record by Mr. Akins for his first production. Okay, so they say, oh, Judge, forget that. There's really secret records out there that we haven't seen yet, you know? So this is the kind of evidence that they're coming up with. And why do they want to make these arguments? Because their whole case hinges on the proposition that all of the probable cases came from Henderson. Okay, and why have they chosen Henderson? Because Henderson just made the 5-gallon bottles. It didn't make any retail bottles. So UNF wants Henderson to be this bad operation and the Desert Inn to be the good operation because the retail bottles were made first at the Desert Inn and later in Mesa, Arizona. No dispute that the retail bottles sold to Haley and Belsky were made at Desert Inn. So what they're trying to do here, Judge, is they're trying to say, and all of their experts say the same thing. Oh, all of the probable cases came from Henderson. And I show them the Wren medical records, and they go, well, it could have been made in Henderson because they were evicted August 10th, so they could have moved it all, hooked it all up, and you show them the testimony. It takes 2 weeks to fill it up, and they go, they don't have any answer to that. But this basically destroys 3 of their expert opinions. I mean, Mr. Revchak, there's a motion later on, he's their mechanical engineer. He goes so far as to say his whole opinion collapses if the probable case comes from somewhere other than Henderson. So that's why it's an important motion, Your Honor. Now, okay. Shane, can we pop up Mr. Jones's testimony for reply page 8? I talked about this, Your Honor, but I want you to know where I'm getting it from. Remember, I said let's use Mr. Neale's August 10th date, even though it is so ridiculous that I can't believe he's going to try this with the jury. But let's use it. Let's use that date. Let's say he's got proof that they moved the film machine on August 10th. Okay? These are his questions to Mr. Jones, the deposition. He says, well, after you move the film machine, how long does it take to get it up and running before you can actually make product there? There's other testimony that Mr. Jones gave that suggests the film machine was moved in the first or second week of September, which is when I think it really was moved. But, I'm giving him every benefit of the doubt. So he says right there, let's go back up to the other sheet. Twice, he says it takes a few weeks. So if we use his August 10th date, and we add 2 weeks to it, we're August 24th, we're 11 days past the Wren's limit date. And so they say, well, Judge, there's evidence that there's a factual dispute here. Let's hear it. Let's hear what he gets up. Let's hear what evidence he has. Doesn't have any testimony, doesn't have any affidavits. All he's doing is he's going off this eviction date and trying to hook this and hook that and hook this. So that's the first point. Second argument they make. They say that Christopher Wren doesn't meet the definition of similarity for prior incidents in Nevada. Okay, we know Nevada has probably, I don't know if we're the most liberal, but we're pretty liberal in prior incidents. You start with, Mapes Hotel is one of my favorite cases. They let in the 16 instances of prior doors. The Robson case is a box machine. They let in evidence of malfunctions before the accident and then after the accident. And they let it in for not just the box machine being litigated, but other box machines that they say are analogous. So similarity in Nevada is pretty easy to establish on a prior incident. But how can they be even arguing with a straight face that Christopher Wren is not a prior incident when he's one of the 21 probable cases? Okay, I just don't see it. But Your Honor, his date, again, the vomiting was August 18th. Ryerson's after that. Hughes after that. 2 of the other cases, Mr. Botiz and Mrs. Arnone, they're all after that. So number one, it's a prior incident for all those cases, so it's admissible for that reason. But in addition, it shows it's admissible on causation. Even for cases before, it's admissible on causation because it shows that he drank the real water and he got liver injury. I mean, that should be the end of it on a prior incident case. So that's their second argument. Oh, it's not similar. And then their third argument, which I really love. Oh, you can't talk about prior incidents, Mr. Kemp, unless you bring in all the medical records and you call 6 different doctors for each one of the prior incidents. That's the argument they're actually making. That is complete garbage, Your Honor. There is no Nevada case, and I haven't found one anywhere, that says we have to have medical causation testimony to admit a prior incident. And why is that? Because prior incidents are being offered for notice. In the Robinson case, there was no medical testimony for these other box accidents. In the Mapes Hotel case, there was no medical testimony from 16 other doors. There's no medical testimony. And the only medical evidence that they need is what I've already given them that they can match up the Red case. And I don't even think that's in dispute, Your Honor, that Red's the first case. So with regard to their argument, they didn't cite any case law, but I did some more work, and I found this case. It's called the Beniti case. It's an interesting case from the Fourth Circuit, which Mr. Neale's probably familiar with because he's from the Fourth Circuit. But let's pop that up, please.
I don't have that one, Mr. Kemp.
Let me just read you the whole, Your Honor. This is cited in our reply to motion for summary judgment number 1. And Mr. Parker, someone's made it on mine. Okay. This is what Beniti holds. It's on page 15 of the reply. Quote, when prior incidents are admitted to prove notice, that's what we have here, the prior rain incident being admitted to prove notice, the required similarity of the prior instance to the case at hand is more relaxed than when prior instances are admitted to prove negligence. And in their opposition, they cited a negligence case. I don't really want to get into it too much, but it's Eldorado versus Graff from 1964. In that case, the court said, oh, well, we can't tell the jury that there's a piece of lettuce on the floor 6 months earlier because this is a negligence case. So they did exclude it, Your Honor, but it's completely different liability theory. This is strict product liability theory. You apply the more relaxed standard. The conclusion, the instance need only be sufficiently similar to make the defendant aware of a dangerous situation. That's the test in Nevada too. So like I've already said, sufficiently similar. This is one of the 21 probable cases. How can it not be similar? So with that, Your Honor, I would stop here with the exception of saying this is a key issue of the case. I agree with you. It's such an important issue. This is why we addressed it in motion for summary judgment number 1. This should not, they're going to get and say, oh, Judge, factual dispute, factual dispute, factual dispute. There's no factual dispute. That's why I showed you all the evidence. They don't want this determined against them because they know that it proves, or at least it creates a strong inference that there's a common problem in both plants, not just a unique to Henderson problem. But evidence is undisputed, Your Honor. That's why this motion should be granted. And all we're asking is that the court determine that Chris Rand drank water from the Henderson plant. That's all we're asking. Okay. We're not asking that this proves that real water was bad, or that this proves that UNFI's arguments are ridiculous. I think it does, but that's not what we're asking the court to do. We're just asking you to say it's an undisputed fact that he drank the water that August 13th home delivery came from Henderson. That's all we're asking.
Yeah, Desert, right?
Desert, excuse me.
That's what I thought.
Yeah.
Whoops. Good morning, sir.
Good morning, Your Honor. Nicholas Hoffman for UNFW.